Hi, my name is Carrie Sheehan, and I'm with Tips Magazine. And here with me today is Xuan Nguyen, and I'll be asking her some questions. But first, I'd like to have her speak and let her tell you her background and how long she's been an attorney and all that. So here you go.
Well, hello, Carrie, and thank you so much for having me do this interview. I am an attorney here in based here in San Francisco. I've been practicing for over 13 years now, and I went to law school in California, as well as did my undergraduate in California at the University of California, Berkeley, and then on to UCLA School of Law. And some of my practice areas that I work in are labor and employment law and general business litigation. And these are areas that are really critical, I think, to any business person wanting to conduct business. You're inevitably going to have employment issues as well as, heaven forbid, litigation issues that may arise.
Absolutely. Thank you for that. And thank you for having us here at your office, lovely office. I'm going to start off with the first question. What are the top 5 things that an employer must do when opening his or her business, in your opinion?
Of course. Well, Carrie, here are some of my recommendations. First, for business owners wanting to start a business, the first thing I think they have to think about is what type of entity do I want? For example, there are various types of entities that are available to someone who's considering starting a business. Do they want to be a sole proprietor? Do they want to be an LLC? Do they want to be a corporation? And with respect to corporations, what type of corporation? Because you have a C corporation and an S corporation. Later on down the line, I can get into some more detailed information about some of the advantages and disadvantages. But for today's interview, that's one of the things that I would have an employer consider, a business owner consider. The other thing I would really recommend to potential business owners are having someone draft up an employee handbook. Now, oftentimes I hear of stories where people try to download these documents from the internet, and I highly advise against that because there's so many versions out there, and they need to be tailored to your specific business practice as well as the jurisdiction in which you practice. Another thing that I would recommend to business owners are think about agreements, employment agreements that are important, because within those employment agreements, there are provisions about protecting your proprietary information, your intellectual property. So if you've got an idea or a concept that you want to protect, you want to think about putting that in an agreement. And certainly an employment agreement will also have other things that you'll want to have in written form so that it's clear between you and whomever you're doing business with, including specifically your employees. The other 2 things that I would highly recommend are consider getting employment insurance, especially in a jurisdiction like in the United States where it's very litigious. And a lot of these employment lawsuits can really range in the millions. Sometimes having employment insurance will help offset some of those costs to reduce the risk to a business owner. And finally, I think a business owner also needs to think about having workers' compensation insurance. Now, at least in California, if you have just one employee, it is mandatory that you have a workers' compensation insurance. And the failure to do so could result in extraordinary fines.
Wow, those are some really good tips. Employment insurance, now that's something that I've never really considered or even heard of, so I'd like to hear more about that. So thank you for those 5 tips. The second question that I have is the most common mistakes employers make with their employees, in your opinion?
I think some of the common mistakes include, for example, what I may have alluded to before about not having an employee handbook, because having an employee handbook really sets forth in written form clear policies and procedures that govern the employment relationship. And also, if you get into a lawsuit, you can point to those policies as part of your defense, and that's really helpful to have. Moreover, it's also helpful to you as the employer because you know what you need to comply with, and often those policies are set forth in that handbook. Another common mistake that I see employers make is that they don't keep up with current employment laws. Employment laws are constantly changing, especially in California. I mean, by the month. I mean, you have minimum wages that change. The federal government also came out with new rules and regulations with respect to the amount of money you have to pay an exempt employee in order for them to be considered exempt. So that actually raises the overtime calculation. So it has a sort of a domino effect on the other employment laws and on your other employment practices. So it's really critical that they keep up to date with the ever-changing employment laws. The third thing I think employers commonly make are they don't understand they misapply the concept of PTO and vacation policy. In California, at least, which is the jurisdiction that I practice, vacation isn't mandatory. But if you do have a vacation policy, for example, then once an employee leaves, you need to pay it out. But again, you don't have to have a vacation policy. While it's recommended and preferable because you want your employees to have time off, but again, it's not required. And some people, I think, confuse that idea. A fourth thing that brings to mind in terms of mistakes that employers make, I think, is that they fail to document important conversations and agreements that they have with their employees. So if you have a conversation and for whatever issue that is going on and you fail to document it, in the end that can kind of work to your disadvantage because you can't prove what took place during that conversation. So I think it's really critical that in the employment relationship that you have clear documentation about what is discussed and what the conclusions that are reached. And finally, I would point out that another common mistake is not understanding the concept of how to apply reasonable accommodation. In California and in the United States, an employer has an obligation to make a reasonable accommodation when employee requests for such reasons as a medical disability or health reasons, and not understanding how the interplay of these laws relating to reasonable accommodations at both the state and federal level can really, I think, expose an employer to liability. I'm sorry, I've really gone on and on, but those are really some of the common mistakes that I see over and over again with respect to employers.
I must say I'm learning so much from you just right at this second.
We're just skimming the surface for the moment.
Yeah, I mean, as you're speaking, I'm just coming up with more questions in my head. So I don't know if we have time to actually do that. The one thing that you had said, documentation. I know documentation is always key, but should you also have a witness in there with you when you're documenting or reprimanding or whatever you're doing with that employee?
Absolutely. I think that it's highly recommended. Also, and especially, for example, when you're disciplining someone or you're terminating someone, you want to have a witness there who can take notes and yeah, exactly, can testify as to what took place, and who could be a witness later on if it should ever be a problem.
Okay. Well, thank you for that. So the next question I have is, what does it mean when when people say somebody is at will?
Sure. At-will employment, that is pretty much the standard of employment in California. And what that means is when you are an at-will employee, it means that you can be terminated at any time for any reason, so long as that reason is not unlawful. And it also means that you can leave employment at any time. It cuts both ways. So in terms of practical application, if you hire someone and you decide that and this is sort of an extreme example, but let's say you simply don't like the fact that they come to work wearing a green T-shirt. That's kind of an extreme example, but the idea is that you're free to terminate them at any time, and they are free to leave at any time. But again, you can't terminate them because they're a female, or because they are 50 years old, or because they profess a certain religious belief. If you make a termination based on those reasons, you're exposing yourself to huge liability, and it is illegal to do so. Now, employment at will is in contrast to contractual employment. This is where you have an agreement and you say you will hire this person for a specified period of time, and they can only be terminated for cause. And cause is often defined for various reasons: performance, and usually performance or failure to hit certain metrics, whatever it may be that is in your employment agreement. So employment via where you have a contractual relationship is in contrast to employment at will, where the person can leave at any time, you can terminate at any time, but again, by contract, you are agreeing to most likely employ them for certain periods of time. This is often in the case of really high-level executives, where they have an agreement that they'll be employed for a specified period of time, and if you should terminate them, it would have to be for cause. And there's also certain severance items that they would be entitled to that is negotiated as part of that contract.
Very good, thank you. Should an employer let the employee know why if he or she is being let go? I asked this because I had a conversation with a certain individual, and we were just going back and forth. So would you explain that for me?
Sure, of course. I think that I would definitely, there's no harm in telling an employee the reasons for why they're being let go. Obviously, these are not reasons you should simply make up and as pretext for the real reason. For example, if the real reason for why you're terminating an employee is because you don't like the color of their skin, and you are conjuring up a reason so as to hide the true reason, which true reason is illegal, then it's problematic. But by and large, I think it helps facilitate the termination when you can provide a reason, and to help the employee understand why they're being let go, so long as that reason is legitimate, bona fide, and of course not illegal. And I think it also helps with respect to the sort of helping to preserve that relationship, because you have to understand that when an employee is terminated, it can be a very emotional experience, and they're likely to be angry and to maybe want to take further legal action, whether that legal action is warranted or not. So sometimes providing them with an explanation, I think, helps smooth that just to smooth that process.
Okay, and this may be linked with just this last question that I had asked you, but can you let someone go at the end of their probationary period without giving any explanation?
And the answer to that is yes. Again, this coincides with the concept of employment at will. And in fact, I would argue that you could even let them go even before the probationary period ends. Oftentimes in employment handbook, an employer will say, you know, an employee comes on board in the first 90 days as a probationary period, and then they can be subject to being let go at the end of that period. But they can also say that doesn't detract from the employment at will policy, which is that you can be let go at any time, which includes the time within the probationary period. So again, consistent with the concept of at will employment, an employee can definitely be let go at the end of the probation period, as well as even before, because certainly the idea of the probation period is that you're trying them out, and within the time that you're trying them out, if something comes up where you just think this is not a good fit, then you're entitled to let that person go.
Very good. And you don't have to probably give me an exact amount of, you know, the next question that I'm about to ask you, but what would be maybe a range of, you know, purchasing a handbook, or you drawing up a handbook for a company, or a contract for the employer?
Sure. Well, I think the question is twofold. One is with respect to contracts, and one is with respect to an employee handbook. Now, with respect to the employee handbook, I think it depends on the size of the employer. If you're an employer with 50 more employees, then you're going to have a much larger handbook, and there are much more employment laws that you need to comply with that need to be in the handbook, including dealing, for example, with the Family Medical Leave Act, which is a federal law, and that kind of law, for example, only applies if you have 50 or more employees. But sure, if you're a small 5 to 10 employee employer, then you won't need to have those provisions in there. So your handbook will be much smaller, and the cost will be reduced. Typically, it's a couple $1,000s at least, a minimum, I think, to have one of those drafted up. And a lot of it is just a lot of that time is spent communicating with the business owner regarding their business practices and understanding their business, so that those laws and those policies can be adapted to their specific needs. And that, I think, is really what's critical. And that's why I don't recommend that people go online and download something, because oftentimes they end up wedding themselves to policies that they don't need to be compliant with, and then that exposes them to liability unnecessarily. Now, with respect to employment agreements, that's only maybe a few hours work, if even that. And so it's actually much less. But those can be crafted pretty easily. They're not as involved and labor intensive as opposed to employee handbooks.
The next question, what's the costliest litigation you had done, and how could that have been avoided?
To be honest, Carrie, in some instances, no amount of prevention can prevent a lawsuit that will come. But that being said, I think an ounce of prevention is definitely worth the cost. So I think the most costliest litigation that I've seen and that I've experienced in the employment context is our class actions involving wage and hour violations, as well as issues of misclassification. But by wage and hour, I mean issues dealing with whether the employee got to take their meal and rest breaks, and whether the employer documented that they took that meal break, for example. And when you compound that with a class action where you have hundreds of employees or hundreds of class members, even if one person only missed a few hours of their meal break, the penalties can be compounded. And similarly, the same thing with misclassification, which is a huge issue right now going on in the news. I don't know how many of some of your viewers are aware, but in California, for example, a lot of the shared economy industries such as Uber and Lyft have been facing these types of wage and hour, employment class action type claims. And the result was a settlement, but it was, I think, I don't want to quote me, it was somewhere in the millions or billions, but suffice to say, it was a lot. And so I think, and certainly a lot of the business owners are not there of the Uber and Lyft extreme in that, but still, I think if you can consult with legal counsel on your employment practice, it will go a long way towards reducing future litigation.
Wow. So much I've learned. I mean, Uber and Lyft, I've never even thought of going in that direction with this interview today. Thank you for that information. Something to really think about. And I think this is the last question that we have at the moment. So what would be the best advice you can give to new business owners with less than 50 employees or more than 50 employees?
Well, Carrie, I'll keep my answer brief on this. And I think really the best advice would, especially if you have more than 50 employees, but even if you didn't have more than 50 employees, whether more or less, I would say really consult with legal counsel on your employment practice on an ongoing basis. Don't try to go at it alone, because oftentimes you would just get into trouble, and you probably, if you think you're doing something wrong, you probably are doing something wrong, because employment law actually is not that intuitive. And I'll just give you an example. I had a situation where I think a few years ago where employee was of the opinion that if they didn't allow an employee to work overtime and an employee worked overtime, then they should not pay them. Well, no, I mean, contrary to our, I think, natural thinking, the law is that if an employee works overtime, you have to pay them whether you authorize it or not. But your remedy really is to terminate them or discipline them for doing so. But at the end of it, you still need to pay them for that overtime. And so I guess that's just sort of an example of where an employer may get tripped up. So in answer to your question, please consult with legal counsel on an ongoing basis.
Thank you, Zwan, for your time. I certainly have learned a lot, like I said, and to avoid anything that you can get tripped up with or get in lots of lawsuit, make sure you contact your local attorney, your labor attorney, and I certainly would recommend Zwan Nguyen at this time. So thank you so much.
Thank you so much, Carrie. It's been a pleasure.